Well, we'll just start talking about the Rucho versus Common Cause case on partisan gerrymandering. The one thing that's not clear to me, even though I read the entire decision, is whether or not a partisan gerrymandering is illegal, and at what point a partisan gerrymandering becomes illegal. That wasn't clear to me in the decision. Is there a standard for that?
You know, I think the way to explain it is there are things that are illegal in redistricting to disadvantage particular groups because of their group status, whether it's by race or other classifications. There's nothing expressly in the Constitution or otherwise that would make illegal gerrymandering strictly for partisan purposes, for example, just on the basis of how many Democrats or how many Republicans or even how many independents or other parties live in a particular proposed district. Yeah. So no, there is no sort of clear and express limit to that at the moment.
So, and one of the things in the dissent that I think the minority kind of glossed over was the fact that the difference between the protections for ethnic groups, like, for example, the famous case in Los Angeles, Garza versus County of Los Angeles, where a particular ethnic community was cracked into 3 separate districts, and a political affiliation, which is a choice. It's not an immutable characteristic. Right. And so they seem to conflate the two and said it's just as wrong to crack a group of Democrats as it is to crack a group of Hispanic residents. I don't know that makes sense, though.
Yeah, I mean, and in some ways, it's all a bit of a fiction, isn't it? Because, you know, when you're talking about packing and cracking, which are the two things you can't do with minority communities, either pack them all into one district so that simply that district has the influence of the local community, and you can't crack them, which means breaking them up so that their influence can't be a majority influence in any particular district. But I think we certainly realize that those things are done because of someone's belief of how a particular community is going to vote anyway in a partisan election, regardless of what their registration numbers are. So in essence, we are simply cutting out one particular way of describing the influence of that community, their registration value, registration numbers, as opposed to, as you say, their characteristics as an ethnic or racial or minority community.
Yeah, and so long as courts have intervened repeatedly when it comes to violations of one person, one vote, where you have population disparities in districts that make votes diluted. They've intervened in racial gerrymandering cases like the one I mentioned in Los Angeles. But have they ever intervened in these extreme partisan gerrymandering cases to where the Supreme Court has upheld a standard for saying, no, this is too far, you can't do that?
No. In fact, this was the sort of ultimate test of that. The cases in the district court and the courts of appeals that made it to the Supreme Court at this time, courts did in fact try to take on that question, really for the first time. There have been indications over the last few decades that perhaps the Supreme Court was beginning to take an interest in formulating some sort of standard, especially because, as you know, over the last 25, 30 years, the division and partisanship in this country has hardened to a level where it has interfered with voting patterns in much the same way that someone trying to interfere with the votes of minority communities. But those cases, when you're talking about ethnicity or race, those lead to an equal protection violation. You are diluting the votes of a particular minority community in violation of the U.S. Constitution. Partisan gerrymandering doesn't have that same hook, right? Democrats, Republicans, members of other parties are not protected classes whose votes are seen in that particular prism the way that minority communities' votes are.
So really, there is nothing, legally speaking, that the Supreme Court is going to do to stop partisan gerrymandering, even extreme partisan gerrymandering.
Well, the upshot of last week's opinion is that even if we could, we wouldn't. Not only did they say we cannot find express authority and a standard for managing this, but that it is the business of legislatures and eventually the people to sort it out for themselves. There's a political question. It arose through the accumulation of political power and patterns of voting, and it should be resolved that way. And that was their decision.
What impact, if any, do you think this ruling will have in the next couple of years as Nevada goes about redrawing its district lines? If Democrats are in charge, and it looks like there's a pretty good chance they will be, will this embolden them to draw maps that favor the Democratic Party and keep it that way for the next decade or so?
Well, I mean, any political party that has the ability to will seek to enhance or keep its power through the redistricting process. Redistricting is the most political process there is. There's no doubt about that. However, I mean, in some ways, this decision is a defense of the status quo. People have been gerrymandering on a partisan basis forever. This merely says you may continue to do that, and that the relief that anyone who opposes that must seek won't be at the federal court level. In this state, much like others, there are particular alignments geographically that make it difficult in the end to draw the perfect map you want to retain your power, whether you're a Republican or you're a Democrat. So there will always be a recognition of geography and politics on the ground that you have to redistrict around, right? Whether it's at the legislative level or at the congressional level.
Yeah. Do you think that, well, first let me ask this. Are there standards in state law that apply just in Nevada that would prevent a extreme partisan gerrymandering? Or
no.
There's no?
No, not at the moment. What there is back in 2011, and I think back in 2001 as well, there were sets of rules and standards drawn up for the legislature to follow, which they put into place themselves, the members of the legislature. And those will have to be sort of re-authorized and followed, but those mainly track the sorts of things you can and can't do lawfully, which is packing, cracking, trying to split up geographical groupings, lines that make sense as opposed to the shapes you sometimes see. Yeah. People try to minimize that through the rules, but there's nothing at the moment regarding partisan gerrymandering either in state law or in the rules.
Interesting enough, I recall during the 2015 session, one of the rules included in the joint standing rules of the Senate and Assembly was the ability of the majority party to take on redistricting mid-decade, which was sort of there as a threat, like, if things don't go our way, we're going to redraw these district lines that have tended to disfavor us, even though those lines were drawn by a non-partisan three-member special masters appointed by the district court in Carson City.
Well, that's a fairly brazen attempt to take advantage of what's not in law. What's in the Constitution is that these lines must be redrawn every decade. A decennial census lays the groundwork for it, and then those lines are drawn. There is nothing that says you must not do it at any other time. And if you remember, this was a sort of new ploy that came up in the mid-2000s. I think it began in Texas, where with full control, the Texas legislature said, we can draw these even more to our advantage than they had been back in 2001. And they did so. And so the 2015 attempt, when the Republicans in this state were in full control of all three, the Assembly, the Senate, and the governorship, made that particular threat. It's an extreme one, and they didn't go through with it, but there's no saying that couldn't, rear its head again in the future.
Yeah, look, kind of last question on this subject. Since it does appear that the Supreme Court, the majority at least, believes is a political question, and it should be left to the state legislature. Is there a political incentive for the majority party not to grab too much, not to try to go too far with respect to redistricting, or is it Katie bar the door and it's no holds barred now?
Well, when you call something a political question, it's that it must be portrayed and lived with on a political level. So in the end, it's up to the voters. Right? If one of the lessons of last week's U.S. Supreme Court opinion is that if you're expecting the courts to remake our political system, if you're expecting the establishment itself to remake our political system, that's a fool's errand. It is up to the people and the voters. No one's going to organize for you for this purpose. If you want to change these things, It starts with organizing and voting to change them yourselves, because ultimately that's where the responsibility is going to lie.
And there's a second opinion that came out last week that's pretty much related to this, and that has to do with that enumeration you were talking about once every 10 years. The Trump administration wanted to put, for the first time since I think the 1950s, a question on there asking, are you a citizen of the United States? There were some objections made. The case wound its way to the Supreme Court after the state of New York sued. And the first thing about this that I found fascinating was the number of ways that the court found to say that the Secretary of Commerce, Wilbur Ross, had lied about his motivations of putting this question on there. I think there were, I counted 3 or 4 different times that they said, without using the word, right, they said he basically made all of his reasoning up. He just wanted to do it, and he'd planned to do it since the beginning of his tenure.
And it puts the administration in a very difficult spot, because normally when the court says you didn't explain yourself very well, go back and explain yourself again, you may be able to wipe the record and sort of start fresh and lay a groundwork for this question or some other action by the agency. In this particular case, the evidence that has come out since even the filing of the case makes it very difficult for anyone to believe that there is anything other than the purely partisan reasons for doing so. There's actually like a double level to it. The question that was answered was, can you put a question like this in the census questionnaire? The answer that came back was yes, but as the agency in charge of it, you can't lie about why you're doing it. That's what tripped up the administration. And now it's very difficult for them to go back in time for the 2021 census and wipe away all the reasons that everyone knows why they did it, right? It was to depress minority turnout. Now, the interesting thing is that the question of can you put this on the questionnaire is not the ultimate question in this area. The question is, what do you do with that data? Because the court said, yes, you can get that information. The next question is, what do you do with that? Do you count non-citizens in the enumeration? Do you not count them? That will change the map of America and the respective voting power of states and districts across this country, depending on the answer to that question. That would be a case even after this one, which would take even longer to sort of play out. So there's really no time before the 2021 census. People would have to look toward the 2030 enumeration for the impact of this really to be felt.
And the Constitution says that the enumeration shall just be of the population. It doesn't say the citizen population, right, the native-born population, the white or black population. It just says everybody. And these numbers are used to apportion resources to states for various things, to basically decide on the representation and all of that. So the wanting to have this information, I assume there may be legitimate grounds at some level to want that information, but certainly for the purposes of apportionment, it doesn't matter if you're a citizen or not. If you're here, you get counted.
Right. I mean, one of the reasons that the court ruled as it did, yes, you can put that question on the questionnaire, is that there are all kinds of questions, all manner of information that the agency's gathering for all sorts of purposes. It asks, what your household income is, how many people have stayed in your house in the last 5 months, all those sorts of things, right? So there could be theoretically reasons to ask all sorts of questions. Everyone, I think, understands why this question is being asked by the Trump administration. As you point out, it doesn't really matter if you're a resident with a green card, whether you're undocumented, or whether you're a 7th-generation American living in your district. Everyone has to live with the consequences of the decisions by the legislature and the decisions by Congress as to how we live together under the law. We're all subject to those laws. Right? So the counting of everyone, right, recognizes that we are all subject to the law of the land, and therefore should be counted in the enumeration that forms the basis of representation and in allocating resources by the executive branch to the country.
And a lot of people suggested, as you mentioned earlier, that the purpose of this question was to depress the response to the census, which would then have a concomitant effect on the enumeration of congressional district seats and all of that. Do you think that's the accurate thing? I mean, if we're kind of searching as to, we know the stated reasons are false.
Right.
So now we're on a search to find what the real reasons are. Do you think that's the real one?
Well, what made this particularly uncomfortable for national Republicans was the discovery of a hard drive of a Republican consultant who helped work on the North Carolina reapportionment. And turning that over to the court, the contents of it made it perfectly clear that the only reason for doing this wasn't to find out, just sort of how many are where and who else is elsewhere in some sort of neutral fashion, but was specifically intended to not only depress responses, but to eventually build a case for not counting non-citizens for partisan reasons. That this entire effort would benefit the GOP over national Democrats, both nationally and in particular localities. So I think it's really beyond question what the motivation is now.
It's interesting too, because again, we're back to assuming how a particular group of people will or may vote or behave politically based just on characteristics like the fact that they're here illegally.
It strikes me that any party would be better off appealing to people with policies now so that they can win their votes legitimately, as opposed to trying to get around their voting capacity or dilute their voting capacity or sort of brutally taking away their opportunity to vote at all. That to me would be the better path forward.
It does seem like an admission that there's no way they can do that.
Yeah.
And so,
as if we needed that admission.
It's true. Now, you've represented the Nevada Democratic Party. Have you represented them in redistricting cases?
Yes.
Okay.
In the 2011 session, thereafter, there was, as you know, a major case in state court that eventually wound up being decided by by a set of special masters.
Right. So that's the second time you've gone up against Mark Hutchison then.
Yes. No. Mark's an old friend, and he is a worthy adversary.
Yeah. And so you think that there's not enough time now for this question to be placed on a census, and so it'll go forward as normal. If the census is delayed, or if they find another way to put that on there, do you think that effect is going to happen? That there will be an undercount of particularly people who are not here legally?
Yeah. No, I think that. I do think that there's not enough time, because what the court has done, what the Supreme Court has done, is remand it back to the agency, Wilbur Ross's agency, to come up with new explanations as to why they need it. That will then go back to federal court, and all the matter with the hard drive and that evidence has to be gone through, and then Court of Appeals, and then back to the Supreme Court again, and we still haven't gotten to the other question, which is what you do with that data once you have it.
Yeah.
It strikes me that there's very little time, given the official deadlines, for that to make it on.
So two things on this. One, you can't give a justification to say we want to depress turnout.
Yeah.
Obviously that would be illegal, and so you couldn't say that.
They're a bit stuck now.
And then the second thing is that I just lost that second. I had a second aspect of that question. If you did put it on there and you did gather that information, it still would not be constitutional to make a case to not count people who are here illegally.
You could make the case that what the Constitution means is American citizens. It certainly doesn't say that. That's a very difficult road to hoe, I think. Yeah. But that doesn't mean that those kinds of things can't be attempted by those with the opportunity to do so. Here, the GOP. Your original question is, will there be a depressed response? I think that the publicity that this matter has already gotten probably will have some effect on that already. So that the GOP has gotten some of the effect that it was shooting for anyway, even in losing. I think it would be greater if it did get on. The notion that we're somehow that it's possible to delay the census, I think, is far-fetched. I can't think of any situation in the history of this country that's happened for these kinds of reasons, much less, well, really any reasons. There are particular deadlines where the data and the information is transmitted to the states, gotten back from the states, their lines are drawn, they have to be in place for elections, right? In the year 2022. So I think it's very unlikely there'll be a delay in any of those processes.